Amber Dawn Kelly was convicted of delivering fentanyl and hydrocodone following the overdose death of her friend Nicole Overton, age 23. She is appealing her conviction, arguing the Superior Court should have suppressed messages found on Overton's phone, they should not have allowed testimony from Overton's parents indicating she did not visit after the death, and she also argues prosecutorial misconduct and that the trial court erred when denying her release on bond during the appeal. Let's check it out.
Miller for the appellant, is that correct?
That is correct.
All right, and Mr. Miller, did you want to reserve any time for rebuttal?
5 minutes, please.
All right, and did you hear me explain how our clock system works?
This yellow light will turn on and I will.
It will, and the trap doors will open, and
Won't be the first time, Your Honor.
thank you, Mr. Miller, go ahead.
Thank you. Your Honors, first of all, I'd like to start out by saying that when the young lady passed away and the officer came to her room, he immediately knew that a crime had likely occurred. And suspicion of a crime generally requires that a warrant be obtained.
Why did he likely know a crime had occurred?
Well, there was a young lady who had passed away, and it was pretty evident that she passed away from a drug overdose. And based upon that, he started.
Why was it evident she passed away from a drug overdose?
Based upon her roommate providing information as to what took place the night before. Can I answer your question?
So,
Yes, thank you.
You're welcome.
so the officer asked for her phone or obtained the phone?
He obtained 2 phones, not just 1 phone. He obtained 2 phones. He wasn't sure which phone was what he didn't really know what was going on. And I would refer to State v. Boise, 194 Washington 2nd 1, 2019 case. Based to start off as far as what the officer should have done. He should have went and got a warrant for both of those phones, but he didn't. Instead, what he did is he contacted the parents, who miraculously inherited the phones immediately.
Who owned the phone before Miss Overton's death?
Ms. Overton.
Did the trial court find otherwise?
The trial court did find that she owned the phone and stated that the parents.
Trial court found that Miss Overton, rather than her father, owned the phone?
I believe that the trial court found that Ms. Overton owned the phone and that her father inherited her phone immediately upon her death, as far as her estate is concerned, because he was her own inheritor, could have inherited.
Is there any significance to the fact that the father was paying for the phone and didn't consider it a gift?
Well, I believe there's case law on that already talks about the fact that if a parent gives a child money or pays for something, that is presumed a gift. And I believe it would have been the viewpoint of the daughter, Ms. Overton, versus the father. She was receiving that phone. She had care and custody of that phone. She controlled the passwords to that phone. She was the exclusive user of that phone. There was no evidence to indicate otherwise, that anyone else had access to that phone. The parents had to provide 2 separate passwords that they thought might work, but they weren't sure what the passwords were exactly, and the officer then obtained, used both of those, and one of them worked. I can't remember if it was the first or second password. One of them did work.
So, Mr. Miller, would you agree that if Phil Overton owned the phone that his adult daughter was using, that he would have authority to consent to a search of that phone?
Well, not really, Judge. If you take a look at the case involving the landlord, and I forgot the site on that, but there was a landlord who owned an apartment building, and someone had passed away in the apartment building. And he gave permission to the officers to search the apartment, and the court found that that permission, even though he owned the building, was not valid because the person had exclusive use to the apartment.
Is it possible they could be co-owners of the phone?
I don't believe so in this case, because of the control of the phone, and the password was Ms. Overton, the young lady's exclusive. The parents had the ability to go in and change or do anything to that phone. They were guessing the passwords were.
Assume for argument's sake that the father owned the phone. Does that necessarily mean that the text messages on the phone are not protected under the Constitution if those text messages were sent or received by the daughter? Stated differently, do we analyze separately the Fourth Amendment and Article 1, Section 7 with regard to the phone and then separately with regard to the text messages?
I believe in this case, the phone would be akin to the apartment. The contents of the apartment cannot be searched, just as the contents of the phone cannot be searched.
So if we agree that the father owned the phone, then Miss Kelly necessarily loses on the search issue?
I know, I believe I answered to the opposite, Judge. I believe what I just said was that the father owns, even if the father owns the phone, the contents of the phone would still belong to Ms. Overton.
And what case law stands for that, other than perhaps the landlord-tenant
Might have that.
case?
That would be. Oh, dang it, I didn't write it down. Oh, State v. Matthew. I didn't write down the site. I apologize.
Macney, how do you pronounce that?
Pardon me, Judge.
What was the name?
State v. Matthew, M-A-T-H-E, and I just cited it. Judges, if this is allowed to go forward, this is going to set a dangerous precedent, this particular case, because it involves three things that I think will completely encroach upon the rights of citizens of the state of Washington. One, that any lay opinion could convict somebody of delivering a controlled substance. I could just simply say that this pill made me feel this way, that person gave it to me, therefore this pill must be oxycodone or fentanyl or whatever I deem it to be. The user becomes the expert.
Well, I think it looks like a duck and it quacks like a duck. The question is whether that's enough evidence.
The duck still has to be tested in the case law, not the statute. You still got to test to make sure it's a duck. It might be a fake duck, but that is a good question.
Is Ms. Kelly's argument that her privacy rights were violated, or that Nikki Overton's privacy rights were violated?
That Ms. Overton's rights were violated, and my client, as a third party, had an expectation that what she sent to Ms. Overton would not be read by any other individual without the permission of Ms. Overton.
Does a deceased person have privacy rights under the Fourth Amendment in Article 1, Section 7?
I believe what you're referring to is abandonment, and you do not abandon property through death. That does not happen.
Well,
And that's under
but let's go specifically, though, to constitutional law regarding searches and seizure. Is there a privacy right under that for a deceased person?
Yes.
And what case law stands for that?
That would be State v. Samala, S-A-M-A-L-L-A, 344 Pacific 3rd, 722. That's a 2015 case. Just
Spell that again, please.
it's cited in my brief, Judge. State v. Samala, S-A-M-A-L-L-A, 344 Pacific 3rd, 722, 2015 case, Judge. The next thing that would take place is that a person would lose the right to have any type of privacy when it comes to your cell phone. Basically, an officer could find a phone, if he could find an individual that could maybe possibly claim that they knew the code, or in some way or other way had some type of, just knowledge of the phone, they could use that knowledge to allow that officer to break in. And again, Judge, I believe that the most important part here is that the officer knew that what he was dealing with may have been a crime. Now, it just has to be suspicion that it's a crime. It doesn't have to be absolute knowledge that it's a crime. And as soon as the officer has suspicion that there's a crime, he has a duty to obtain warrants in order to do searches of anything. And in this case, that simply was not done. And then we move on to the fact that the state in this case enraged the jury through the continuing. And I realize that this is a tender issue, but she put the parents in stands to talk about how tragic the death was. And clearly it was. I mean, any time you lose your child, that's a tragedy. But then the prosecutor went on and pounded the podium to basically say, and you didn't go to the funeral. Because of that, you had consciousness of guilt, and that consciousness of guilt is clearly demonstrated, so you're not. And lastly, Judge, we had a state court deny an appeal bond without making any findings of fact or going through any of the statute that is required. We brought that up again, if you review the record, right at sentencing. And again, the court did not go through the required requirements of the statute and did not make any findings of facts. And Judge, I can see my time is up. So thank you very much. Unless you have questions.
Thank you.
No questions.
Thank you.
Thank you.
And Ms. Learman for the state of Washington, is that correct?
Yes, Your Honor.
Thank you. Go ahead.
The search of the cell phone was lawful. There was sufficient evidence to support the jury's finding of guilty for delivery of a controlled substance hydrocodone. The state did not commit prosecutorial misconduct. The defendant did not meet the burden to prove that the state's conduct was inappropriate or that it substantially affected the jury's verdict when considering the entire record as a whole. And the court did not abuse its discretion in denying the appeal bond.
Miss Learman, you may not be old enough to remember the O.J. Simpson case. Are you familiar with it?
And that I know what the holding was of not guilty, but
Yeah, okay. Mr. Simpson attended his ex-wife's funeral after the killing. Did his attending the funeral show consciousness of innocence?
No.
Why not?
Because there may be other reasons why he wanted to go to the funeral.
Okay. Let's assume he did not go to the funeral. Would that be consciousness of guilt?
I believe it would have.
Why is it consciousness of innocence one way and consciousness of guilt the other way?
So in this case, Your Honor, when you look at the consciousness of guilt, you take into consideration the entire case as a whole. And so in this case, Ms. Kelly, she did not abide by the mores of this small town community. She was a friend of both the deceased and of the deceased's mother. This is someone that you would expect would have gone not necessarily to the funeral. I don't know whether she went to the funeral. The question at the trial.
Maybe she didn't feel good that day.
Well, Your Honor, I don't know whether or not she was feeling good that day. What I can tell you is that within 10 minutes of learning that the deceased has passed away, she started destroying evidence. And that is evidence of a consciousness of guilt. She began deleting.
But that's a different issue, right? I mean, the question before us is whether the state can argue that her failure to attend her friend's funeral shows evidence that she felt guilty, correct?
I'm sorry, Your Honor, can you repeat the question?
Yes. The question before us is not whether her actions in destroying evidence right after finding out Miss Overton died is consciousness of guilt. That's completely separate. We're here today to address the very narrow question of whether the state can argue that the defendant's failure to show up at her friend's funeral was evidence that she felt guilty.
Yes, Your Honor, I believe that is what happened in this case. So the Miss Kelly was a friend to both the decedent and to the decedent's mother. One would expect that someone in that position would go to offer their condolences in person, and that when someone does have a guilty conscience, they may act contrary to what you would naturally assume that they would do, or conforming to cultural mores, which in this case she failed to do that, and she failed to do that. Your Honor, there is also, in order for the court to have found prosecutorial misconduct, they would first have to find that the conduct was improper, and then also, before you would be able to reverse any kind of conviction, would have to find that that singular question was enough to overcome all of the rest of the evidence in the case. When you look at prosecutorial misconduct, you have to look at the record as a whole. That means that you have to look at opening arguments, closing arguments, all of the testimony on direct as well as cross-examine and all of the exhibits. And then you would have to find that the one question that the state asked, that one question would have materially affected the jury's verdict in finding him guilty. And in this case, there was so much other evidence of Miss Kelly's guilt that singular question and answer on direct examination, which was not followed up with in closing argument, would have completely overcome all of the various text messages that Miss Kelly and Miss Overton exchange regarding the sale and the delivery of the fentanyl. And there's simply no way that one question on direct examination could have overcome all of the rest of the evidence in this case.
Ms. Lehrman, let me ask you a question. What's the difference between an evidentiary error and a prosecutorial misconduct?
So for evidentiary error, Your Honor, that is analyzed under the evidence rules for 404, 403, and those cases have to be, they would have to be preserved. The objection was not made under those grounds at the trial court. So the state would argue that that issue was not preserved. That would in fact be the proper analysis for that question, because there wasn't an objection on those grounds under 404 B3 or 1 that any error would have been waived and the court should not consider it.
I want to switch gears here and move to the search of the cell phone while we still have time to do that. Did the trial court find that Mr. Overton owned the phone?
He did, Your Honor. That was findings of facts 12 and 13.
Okay.
That Mr. Overton was.
Do you agree with me that if that simple ownership alone does not give somebody permission to search or grant another person the right to search the property?
Simple ownership alone. So, Your Honor, the tests that the court looks to determine whether or not a owner or a co-owner of a phone, or really a co-owner, would be able to grant consent is whether or not the person had authority and whether or not the other individual who's asserting the violation could have assumed that the defendant basically assumed the risk that the co-occupant might commit a search. And in this case, both of those things did happen. So the trial court found that Mr. Overton did own the phone, both as an owner of the phone in life, because he paid for the phone, he paid for the plan of the phone, he provided the phone to Ms. Overton for her use. She also provided them with the passcodes. The reason why the parents knew the passcodes would have been because they got them from her daughter. So because they had those passcodes, they owned that phone. And importantly, also when Miss Overton was finished with one of those phones, she would return it to her parents. Showing that in Miss Overton's own mind, her parents were the owners of the phone. If she didn't believe so, why would she not have disposed of the phone in whichever way she wanted instead of returning that phone to her parents?
Well, Ms. Lehrman, let me ask you an analogy. A landlord has a key to the house, but that doesn't mean that a landlord can grant police access to an apartment without the tenant's consent.
That's correct, Your Honor. However, I would argue that there's a difference between a home, someone's castle, and someone's cell phone.
What's the difference?
So, for instance, Your Honor, in State v, I believe it's about Hullaby, it is whether or not a owner of a vehicle can override the non-consent of a driver of the vehicle to be able to search that vehicle. And the court looked at the specific facts in the case to determine whether or not an owner of the vehicle could overcome the non-consent of the driver. And so with this case, when you have the cell phone, it's going to be different from a residence because
Why?
one, you're not living there. So there's
I understand that,
different
but doesn't it
privacy
come
interests.
down to expectations of privacy? And a house is one of our foundations of privacy. I mean, we protect the household, right? But now we look at cell phones and we think of all the information we carry on cell phones, and it's like, that's my life right there on that phone. So my expectation of privacy in that cell phone is very enhanced.
But the defendant doesn't have an expectation of privacy in the deceased's cell phone. The defendant only has an expectation of privacy in the unread, in the sent but unread messages from that they sent to the receiver.
What's
Ms. Kelly doesn't have a privacy interest in Ms. Overton's phones. She has a limited privacy interest in the messages that she sent to her, but not her phone.
Well, that harms your argument, doesn't it? Because possession of the cell phone was immaterial. The only reason law enforcement wanted possession of the cell phone was to review the text messages.
I'm sorry, I don't see how that.
Okay, let me ask Judge Staub's question reworded a bit. And I think you've already answered it, but it helps to sometimes ask the same question in a different way. Before Nikki Overton died, did her father have the right to give consent to law enforcement to review the text messages sent and received by Nikki on the phone?
Under the trial court's ruling, Your Honor, yes, he did, because he was a co-owner.
And it requires more than ownership though, right? Doesn't it require control?
And Mr. Overton did have control over the phone, Your Honor. He, as the person who paid for the phone, he could have requested it back from Ms. Overton at any time. He could have put paying the phone bill, which would have disconnected the service to that phone. I will note that as the owner of the cell phone, and the plan and the administrator, that a lot of the contents of a phone, you can back that up to the cloud, for example. And as the administrator of the cell phone plan, he would have been able to provide any of the information that was stored to the cloud from that phone.
But none of that's in the record, right? Now, we
No.
don't know that there was a cloud backup and he had access. None of that's in the record.
No, the cloud information is not in the record. No, what is in the record is that he was the owner of the phone, that he paid for the plan. He was the administrator of the plan. I believe it's all in the trial court's findings.
Did Mr. Overton testify that on occasion he reviewed his daughter's cell phone to see what the text messages were saying?
No, that's not the record.
Is that important in our analysis?
No, Your Honor, just because someone might not have used the authority that they have to do something doesn't mean that they lack the authority to do it.
Let me ask you, the judge made two alternative findings here. One, that he could authorize the search because he owned the phone as the person paying for the phone. And second, and alternatively, that when Miss Overton died, he became the owner of the phone in the sense that he was next of kin.
Correct.
Can you touch on that argument?
So, Your Honor, Ms. Overton died without a spouse. She died without children under the intestate laws of the state of Washington. The parents would have been the next of kin. They are the ones who would have inherited the phone. Rights to you become an heir. Your rights to that property vests at the time of death. So when Ms. Overton died, her parents were vested with the rights to that property in her phone. So even if the court were to find that as a co-owner of the phone, they would have lacked authority to grant consent, certainly upon her death, her property would have transferred to her heirs, in this case her parents, and they would have had the complete authority to grant permission to search to the phone.
When someone dies without a will, at what time does her property transfer and vest, or the ownership of the property transfer and vest in her heirs?
I believe that it would transfer at the time of her death, Your Honor. The property, the interest in that property transfers to her heirs.
What, is there a statute or case law that stands for that proposition?
There was one case that defense counsel cited. It was a little off topic in that it was referring to the rights of a adopted person, but there was a holding in that case that the rights vest at the time of death.
Do you want to wrap up, ma'am?
Your Honor, I would ask that you affirm the conviction in this case.
Thank you.
Getting old, Judge. Your Honor, I believe you're correct when you ask that question about does the property immediately become the ownership, the title to the person inheriting it, and under RCW 11.62, I believe is the statute. 11.62, the minimum is 40 days. So I believe that should answer.
But Mr. Miller, even if ownership didn't necessarily pass, as next of kin, they would be responsible for administering the estate, which would mean that they have control over her property, correct?
But they didn't have title. And
I understand that, but an executor of an estate does, they had
Let
control.
me answer your question.
Okay,
All right. First of all, it's contradictory to on the one hand state that I'm a co-owner of the phone, and therefore I have the right to give someone else permission to use it, even though I don't have use of it. And then to also say that I'm also going to inherit the phone, because you can't inherit something that you already own. So those two arguments are contraindicated. They don't fit at all together. And it's basically you want your cake and eating it too, kind of an argument by the state, and they can't have that.
I
Now-
see it as an issue of control and not necessarily of ownership so much. That
Well-
at the time she passed away, he became the person in control of that phone.
Well, even if you did, and even if you were to allow that part of the case to go forward, you're still going to bump into the part where we don't have any evidence of the res of the case as being any type of controlled substances, which was what my client was convicted of.
Right,
So even if you get past that, which I don't think you can, everything else fruit of the poisonous tree after that. After that, once that cell phone is searched, every piece of evidence after that dies. If you find that that cell phone was improperly searched. Another thing the state just brought up, and I'm glad she did because it reminded me, was she claims that because, first of all, my client didn't go to the funeral, and I believe you were quite correct in your analysis. If she went to the funeral, would that indicate that she didn't do anything? But at the same time, during the presentation of evidence, the state deleted some text messages between the two parties and didn't provide them to the jury. And I lost my mind in the middle of that trial. You can actually review the tape of the trial. You would hear me becoming quite emotional at that
the
particular
state,
point.
I'm sorry, the state deleted?
The state provided an exhibit to the jury where they deleted several text messages that were favorable to my client.
Deleted them or just didn't provide them to the jury?
Didn't provide them, well, they provided pictures of the cell phone,
Oh,
and they didn't provide pictures of that particular,
they
those
took
particular
those
texts.
exculpatory texts out of,
They took the
exhibit.
exculpatory texts out. I lost my mind a little bit. Sometimes I do that in a jury trial. I know some of you have seen me in jury trials before. This was a case decided by a court based on emotions and not law. The court was upset with my client. The court was upset with me. If you review the transcript, you'll see it. It's replete throughout the entire proceeding. Only when my objections were blatantly obvious did I get something that was even close to an acceptance of the objection. Everything was emotional on this case. Everything. I mean, we had the parents sitting there the entire time, and they had the absolute right to be there. Both parents were there. My client's parents, the opposing party's parents were both there. It was a rough couple of days, I can tell you that.
And this was out of Colfax, is that
Yes.
correct?
So it's not a big court. It's a little court, and you're there.
And it's a smaller town.
And it's just, well, Tico is the town that displaced, that was the place.
And that's north of Colfax.
I don't know if you've been to Tico, but I could jog around it, and I can't jog. So it is a small town, Judge. I have 40 seconds left if you have any questions.
Before we run out of time, I don't think you've answered Judge Staub's question, which I think is an important question. And that is, regardless of whether ownership immediately passed to Mr. Overton, assuming he didn't already have ownership, is the important thing that he had control over the use of that phone, the custody of that phone, such that he could have consented for a search.
I'm out of time. I don't believe he could, Judge. I believe that's akin to the apartment case we talked about. Ms. Overton had exclusive use of that phone prior to her death. It was in her care and custody. And I don't believe there's any evidence on the record that would indicate that any cell phones went back to the dad in this particular case, but she had two separate phones. One of them was broken, the other one wasn't. So she had, not only did she have possession of the phone she was using, she had possession of a phone that was already broken. It was not returned to her father.
All right, do you want to wrap up?
I think I did.
Thank you, counsel.
Thank you, Judge.
Thank you, counsel, on both sides.
Following these arguments, the court agreed the trial court committed error when overruling the objection to testimony about Miss Kelly's failure to visit the Overton home after Nicole's death, but they deemed that error harmless. All other rulings were affirmed, and Miss Kelly serves her sentence. Please let me know what you think about this case in the comments below. If you like this video, please like and consider subscribing for a new video every week. Until next time, folks.